Resuming debate, the honourable member for Timmins, James Bay.
Thank you, Madam Speaker. I'm very honoured to rise in this House on this extremely important discussion, and I wanted to thank my honourable colleague from Esquimalt-Saanich-Sooke for the excellent work he's done on this. These are very, very difficult questions. And I understand, I'm glad I was not the point person to have to take the heavy lifting. We may not always agree, my colleague and I, on all the points, but I respect his incredible integrity on this. I would also point out he comes from Esquimalt-Saanich-Sooke, which is like the classic way that English people have misrepresented the First Nation languages, and I think it's worth pointing out. Because when we talk about Bill C-7, one of the things that really struck me in my concern about the bill was the fact that we were dealing with a Quebec court decision that came very shortly after we had brought the legislation in the first time. And the one thing I found with the government, previous government, this government definitely, is that the fact that, for example, if it was a First Nation case, they would have appealed. In fact, I don't ever remember the government not appealing when a court decision happens with a First Nation ruling. And yet with this ruling, we actually had to rewrite the law of the land. And I understand we're on a deadline, but I think it's a reasonable question, given the complexity of the issue, that we would have sought clarification from the courts to make sure that the courts had interpreted this properly and then brought it back to us. So it's something that I find concerning because, again, I'm going to do a little bit of comparatives, which is a standard form of parliamentary debate, of comparing two options, and one option is, again, the issue of Bill C-7, and the other option is, let's say it's a First Nation issue. Let's say it's the St. Anne's residential school survivors, for example, where the government has just admitted that they spent $3.2 million in court fees fighting against the rights of people who've suffered some of the most horrific abuses that have ever been recorded in Canada. Child rape, forced abortions of children, torture, literally torture that was done for the kicks of the staff at St. Anne's through electrocuting children. That's all documented. In fact, Madam Speaker, it was documented in 10 to 12,000 pages of police evidence that was gathered by the excellent work of the Ontario OPP and brought to court, and that the federal government obtained all that evidence. And under the residential school settlement agreement, the federal government was obligated to do two things as a defendant. They were obligated to prepare the list of the history of abuse that happened in a residential school, and that they were then obligated to present all the evidence. And in the case of St. Anne's, the government decided to lie. They said there was no history of abuse at St. Anne's residential school. And they said there was no records showing any abuse. Meanwhile, they were sitting on 10,000 pages of police testimony and witnesses, naming some of the most powerful church people in the land. There was Father Arthur Lavoie, Bishop Laguerriere, Bishop Bello were all named, along with all manner of other abusers. And this was really important, Madam Speaker, because this started under the previous government when Peter MacKay was the Justice Minister and Bernard Valcourt. And I know you're going to wonder how this relates to this issue here, but I know under Bill C-7, some of the Conservatives are talking about a fear of creating two tracks of justice, a set of justice for one set of citizens and a lower set of justice for other people. And I'm not convinced under their arguments on Bill C-7, although I've thought about it a lot, whether they've actually met the test of creating two tiers of justice. But anyone could look at Canada and say, you want two examples of justice? Well, you look at, say, middle-class white people in, say, St. Paul's, Toronto. What are their standards of justice and receiving justice in the courts compared to any Indigenous person in the country? And I think we'd all agree that we certainly have two tiers of justice. And we had that with St. Anne's, because when I approached Minister Valcourt about the documents, he just said, we have no obligation to turn over documents, when they did. And this set this really ugly issue in motion. And when the Liberal government came in, we thought that they would fix this, and they didn't. In fact, they hunkered down. And so when it says that they paid $3.2 million under the present Minister of Crown Indigenous Affairs going after the survivors of St. Anne's who had their cases thrown out because the government lawyers lied in hearings. At the bottom of the order paper question, they said, the Government of Canada prefers negotiation to settle these. I would agree. In fact, in November 26, Timmins Today article, Christina Tricami from the Minister's Department said, the Government of Canada remains committed to negotiating a resolution outside of the courts. And of course we'd expect that this would be the government's position, but that's not true. In fact, I have a letter here from October 15th, 2020 from the law firm of Dion Schultz asking the government to sit down and negotiate a solution. Government said, no, we will meet you in court. Elders Without Borders, representing Edmund Matatawaban, Evelyn Corkmans, other St. Anne survivors, asking the government to sit down and finally end this. Government lawyer said, no, we'll meet you in court. December 1st, 2020, again, lawyers for Dion Schultz writing to the Justice Minister's Catherine Coughlin and saying, at least come to the case management settlement so we can talk about finding a solution. So again, we go back to Bill C-7 where we're talking about two standards of justice. Well, one of the standards of justice in the country, Madam Speaker, is that the lawyers are legally obligated under their professional conduct to find a way out, to compromise. It's under their legal lawyers' ethical duties to compromise or settle a dispute whenever it is possible to do so on a reasonable basis and discourage the client from commencing or continuing useless legal proceedings. How useless are these legal proceedings? Well, in Ontario's Superior Court, where the government continues to lose against St. Anne's, even under Doug Ford's government, the Attorney General for Doug Ford's government came forward to support the survivors of St. Anne's, while the minister who represents her riding of St. Paul sent her lawyers to fight them, and the Attorney General from Ontario agreed that this was cruel, unusual tactics. So under their professional obligations, they're called to find a solution. We have the survivors asking for solutions. I remember talking to the Minister of Indigenous Crown Services, begging her to just meet with the survivors and end this vicious, vindictive campaign against them, and she met with them. I was there as the survivors cried, and you know, the survivors said, we just want to settle down and meet with the government. And the minister promised, and then the next day, they were back in court. And Angela Shishish, powerful, powerful survivor, said, quoted, I'm going to quote this, I'm not making this up, APTN, June 18th, 2018. She said, she lied to me. She lied to me. It hurts. It's just another abuse. When you talk about the survivors of St. Anne's and the abuse they've seen under this government, they talk about the re-abuse that they've suffered for having to come forward to talk about the horrific crimes that they suffered, to be told they were making it up by the lawyers, to be told that there was no evidence. So I go back to Bill C-7 with the Truchon decision, and I was considered that the government seemed to have gone further than the Truchon decision. So let's do some comparatives. Let's talk with St. Anne's. Under the obligations that they were ordered in January 14th, 2014, was that they had to bring forward the POI reports, the person of interest reports on the perpetrators of the child crimes. They were obligated to do that. They were reordered in January in 2015 to do that, and they refused. The Government of Canada decided to protect the perpetrators. So what does that mean, Madam Speaker? Well, on Father Arthur Lavoie, they provided a 2-page report when in fact they were sitting on 2,472 pages of crimes against children, and they had a case thrown out, the case H1509, who was a victim of horrific child rape. And this government decided to fight this survivor all the way through Ontario hearings, all the way through the BC Superior Court, to shut down his right to just get justice for the only crime he committed was being a child, an Indigenous child. And we talked to that Minister for Crown Relations, and she said, I will make it right. I'll call Edmund Matatawaban, the leader. Well, the only time she ever called him was to force him to come and testify on a stand by her lawyers. This man is a Governor General's Award winner. So when we talk in Bill C-7 about 2 tracks of justice, I say, oh yeah, can you imagine a Governor General's Award winner from downtown Toronto being hauled by the minister's to court by the minister and forced to testify over the fact that he's spoken up against horrific child abuse, rape, electric torture, the abuse of children at St. Anne's that still hangs out like a dark cloud. So, Madam Speaker, I know you're asking, why are we talking about comparatives on a bill like this, on a day like this? Well, because once...
And the honourable member will have to answer that during the questions and comments, but we're already over time.
So I'm glad he's given me that opportunity. Words like reconciliation. Reconciliation has to mean something. And you know what? There's no such thing as reconciliation in Canada as long as that member from St. Paul's is hosting her vindictive, vicious campaign against survivors of some of the most horrific abuse, while this justice minister is spending millions of dollars fighting the survivors of St. Anne's Residential School. There's no such thing as reconciliation in this nation, and there's no such thing as honesty or integrity from a government that made those promises to survivors who looked them in the eye and then turned around and sent their lawyers after them. Until that's rectified, it's all just talk over there.